Well, thank you, Mr. Benevolent Chairman. And Professor Barron, thank you for being here. Welcome. You and I have known each other a long time. We went to law school together, and we've always gotten along well. And I would note then as now that you have always been a man of the left, and you have emphatically and effectively advocated positions, very liberal positions, both as a policy matter and a legal matter, and I respect that consistency. I would be less than candid if I did not confess that I have concerns that life of advocacy is not consistent with the role of a lifetime federal judicial appointment. And so I'd like to spend some time discussing that. And I'd like to just start with a general question. Do you embrace the notion of a living Constitution?
As I said to Senator Lee, what I understand the Constitution to be is a written Constitution whose words cannot be changed by a judge and are in that sense frozen. And to the extent that the original intentions aren't knowable in certain contexts or can't be resolved clearly, the court and the precedents of the court make clear that in some instances it's appropriate to look to the practices of the branches to give shape and meaning to them.
So is that a yes or no on a living Constitution?
I think it's a no in the way that if I am understanding, you're asking whether I agree with what a living Constitution is.
You have also written in defense of what you've characterized as a progressive view of the Constitution, which is an altogether appropriate view for someone in the academy to advocate. But you have discussed that progressive view of the Constitution not from the perspective of an academic, but from the perspective of how courts should enforce it. And indeed, you have written that in favor of what you described as, quote, the progressive potential of a significant wielder of power, the courts. And you went on to embrace the notion that the courts should, as you described it, quote, conscientiously arrive at progressive constitutional outcomes. And I'd like to ask if those are still your views, and if you think it is appropriate for courts to conscientiously arrive at progressive constitutional outcomes.
If the idea is that the task of a judge is to come to that outcome because it is a progressive outcome, I most emphatically disagree with that position. Any outcome that's reached has to be based not on the progressive or conservative impulses of the judge that they may have had in a life before that they were a judge. The only thing that can be determinative is the legal position, and if I may, to try and give you some confidence that I truly do mean that, I guess I would point to a couple of things, which is the quality and content of the opinions that I wrote when I was entrusted with making decisions as a legal advisor on sensitive matters. And then in addition, I was gratified by the letters in support of my nomination by people who I think quite clearly reject the idea of a living Constitution, who know me from a variety of circumstances and believe that the way I would conduct myself as a judge is in accord with what I'm saying to you today.
I would note that one criticism that has been leveled at you is that you were highly critical of executive power when it was administered by a Republican, George W. Bush, and then very defensive of executive power when it was exercised by a Democratic President, Barack Obama. And some have suggested that suggests less than consistency or the impartiality that we would hope to see in a federal appellate judge. In your view, are there instances in which President Obama has exceeded his executive authority?
Senator Cruz, I don't feel I'm in a position to comment on that beyond the circumstances in which I gave advice about the particular questions that were presented to me.
Let me help you on that. Setting aside your time at OLC, where you had the responsibility as a lawyer, I'm asking for your view as an academic and commentator. When George W. Bush exceeded his legal power and ordered the state courts to obey the world court. I spoke out loudly against that and indeed litigated the position against the president before the Supreme Court. I'm asking, have you publicly criticized President Obama in your capacity as an academic for ever exceeding executive power?
I have not written about executive power since returning to academia, if I recall. But can I just answer the thrust of the question, because I do think this is important. There was a lot of criticism lodged against the prior administration by academics. The particular criticism that I lodged was one in particular, and it concerned the authority of the President of the United States as Commander-in-Chief to act in the conduct of war unrestricted by statute. That was the subject of the constitutional analysis. When it wasn't an analysis, it was the academic writing that I devoted myself to figuring out what the answer to that question was. But I tried to be tailored, though I felt strongly about that particular issue. That was the particular claim that I was focused on.
And if I may ask one final question, what is your view of the critical legal studies movement in the legal academy?
Senator, I haven't thought about the critical legal studies movement in a long time. I just, in all honesty, I know it was a movement that I think by the time you and I were in law school was, dead is probably an unattractive word for it from the eyes of the people who were part of it, but I have no view about it.
Thank you, Professor Barron.